Welcome to the Pacific Research Institute's Next Round podcast. I'm Rowena Itchon, Senior Vice President, and with me is Tim Anaya, Senior Director of Communications. How are you, Tim?
I'm great. How are you?
Fine, thank you. Well, before we go into the podcast, I just want to mention again, I'm going to invite everyone to our Orange County Gala. The keynote speaker is Kellyanne Conway, and it's on June 11th, and that's a Saturday. It's at the beautiful Balboa Bay Resort in Newport Beach, and Kellyanne is going to be discussing her new book. It's called Here's a Deal, and she's also going to be receiving our annual Baroness Thatcher Award for her work in advancing liberty.
And we always put on a terrific event, so it'll be a fun evening. And if you've never been to the Balboa Bay Club, it's a beautiful place to be. See all, you look out the back and all the yachts are right there. And
beautiful sunsets.
Beautiful sunset. I can't imagine a more, beautiful and fun setting on a summer evening in Orange County than coming to our gala at the Balboa Bay Club.
So, Tim, we're approaching June, and as you know, it's the month when the U.S. Supreme Court announces its major decisions. So I saw a quote the other day from Ruth Bader Ginsburg, who said that it's hard not to have a big year at the Supreme Court. But from all accounts, from SCOTUS observers, 2022 is going to be not only a big year, it's going to be a huge year.
Well, it seems that way, right? I mean, everything, I think, certainly in our politics today, there's a lot of brinksmanship, if you will. And I think the decisions that the court is making this month and some of the cases, that, we know will be upcoming next year, it's a lot of really thorny societal questions that you have a huge divide in America. So I'm sure that the poor police officers who guard the court will be on overtime all throughout the month, and certainly when the abortion decision is handed down. But I don't know if it's from the pandemic or just how divided things are in our country today. But I guess we should not be surprised that our kind of brinksmanship in the political system has found its way to the Supreme Court to have to be that decider.
Well, look what they've had to decide late last year and this year. The court was well into this debate over vaccine mandates. They handed a defeat to the Biden administration as it tried to issue or require vaccine or testing mandates for private employers of 100 or more. And then we had the resignation of Justice Breyer and the confirmation of the first Black female judge, Ketanji Brown Jackson. And then finally, there was the leak of the draft opinion of the Dobbs case, which could potentially overturn Roe. So lots of intrigue happening in the courts this year.
I'm sure they will make a TV movie someday about it, but I'm interested to hear what Erik has to say about that, because still today, how shocking an act that was. You really can make a plausible case. Did some rogue person on the right leak that, or did some rogue person on the left leak that? But it's still a shocking thing to see. We will see when that ruling is handed down. Certainly there'll be the interest in, did anything change in that draft opinion? But B, what will public opinion be? How will people react? Will it be a little calmer and more resigned to what was happening because we had a month or more head start on it? Or will the outrage be and expressions of joy for those who would agree with the ruling, will it be just the same, even though the worst kept secret in town?
Well, so we are lucky this week to have Erik Jaffe of Share Jaffe. And Erik, I think you'd agree with me, Tim, is what we would call a super lawyer. He's been involved in appeals on a broad range of legal issues, including First Amendment, Commerce Clause, challenges to Obamacare, affirmative action in education, First Amendment challenges to school vouchers. He's been involved in over 100 Supreme Court matters. He's filed over 60 amicus briefs, both for cert and on the merit stages. So Erik's going to be great in helping us to provide some perspective on this leak, because he was also a Supreme Court clerk, and he's going to know how could this happen? Why did it happen? Is it even possible? Will we be able to find out who actually did it?
And, it's become kind of an annual tradition that we have Erik on to give us a preview of the hot Supreme Court cases. And I find myself learning so much. And it's so rare that we have, someone, on our team here that, boy, he really has a front row seat to all of these interesting cases. And he has a lot of certainly well-informed observations on these cases. And as we found in the past, as you mentioned, he's usually involved in a lot of these cases that we're talking about. So I think our listeners are, especially those who are interested in the workings of the Supreme Court and follow these cases, are going to be in for a treat.
Yeah, and I think why Erik is so fantastic is that he manages to distill these complicated SCOTUS decisions in layman's terms, but somehow he still, even though he simplifies it, he never really misses the nuances because he's so good and so articulate about explaining this decision. So really happy to have him here, and we think you'll really enjoy the interview. Thanks so much for joining us, and here's Erik Jaffe. Welcome to the Pacific Research Institute's Next Round podcast, Erik.
Thank you. Glad to be back.
So, of course, what's on everyone's mind is the Dobbs case, the Mississippi law that bans abortions after 15 weeks. We all know about the leak of Justice Alito's draft opinion. Any chance any of the justices will change their mind? Presumably the reason why the draft was leaked in the first place. So you were a U.S. Supreme Court clerk. Give our listeners some perspective on this leak. And do you think the person who leaked it will ever be caught?
Well, I'll start with perspective, which is it's vaguely horrifying that someone within the court community, which has historically been incredibly tight-knit, notwithstanding the obvious disagreements on substance, would sort of throw up their hands, abandon that sense of unity, and leak an opinion, no matter how much they disagreed with it. So I am horrified there. But on the other hand, leaks are a fact of modern life and of not so modern life. You have Pentagon Papers, you have WikiLeaks, you have all kinds of things. And so I guess it's hardly shocking that the court would eventually become subject to that. And I guess as someone who overall favors sunlight into government operations, it mitigates my horror a bit. But the overwhelming sense as a former clerk is, I can't believe someone did this. As for whether it will change any votes, I highly doubt it. If anything, it would have the opposite effect. Because now, normally you get a vote at a conference, a preliminary vote. A person gets assigned the opinion, writes the opinion, and you see how it writes. And initial votes may change. Initial votes may get cold feet over some particular piece of the opinion and ask for that to be modified in order to keep that vote. There's a lot of back and forth between an initial draft and a final outcome that this has sort of thrown a monkey wrench into. And so if anything, it sort of hurts that back and forth rather than helps it. And I don't know that was the particular reason for it to happen, because of course the outcome had leaked before the opinion had leaked. Though the opinion gave it a certain amount of concreteness, of course. But I think if anything, it will make it harder for people to ask for and get changes to the draft, because now, of course, the public has a perfect red line comparator to see what changed between the original draft and the final draft. And that exposes a lot of the internal processes, which justices may be unwilling to do. As for whether the leaker will ever be caught, again, I'm a bit of two minds on that. I think a clever and careful leaker could probably avoid detection. It was interesting that the opinion that was leaked was obviously a paper copy. If you look at the version on Politico, you can see the staple holes, you can see a folded down corner, you can see a stamp that's obviously a physical stamp, not an electronic stamp. So somebody took a copy, pulled the staple, and either took photos of it or took a Xerox of it or did something. And that's very hard to get a paper trail to. I guess if they took photos on their phone, you could get a paper trail. But if they just made a Xerox copy, it's not at all clear that can be tracked. It just depends. On the other hand, government law enforcement agencies have shown themselves quite adept at ferreting out information and not overly concerned with the niceties of things like the Fourth Amendment. So I wouldn't entirely be shocked by a secret FBI warrant or just search without a warrant of people's phones and people's communications. So if the leaker was even remotely not careful, then yes, I imagine they will eventually be caught. But if they were very careful, one could have presumably done this in a way that makes it very difficult to trace.
So let's go through some of the big cases that will be coming down in the next few weeks. So one other big case is the New York State Rifle and Pistol Association versus Bruin, which is a major Second Amendment case that limits a person's ability to carry concealed guns. Now, the law requires that applicants show, quote, proper cause for a license to carry a handgun outside the home. Well, the courts have defined proper cause to mean that an applicant must have a, quote, special need for self-protection distinguishable from that of the general community. So the issue is whether the state's denial of two people's applications to carry a handgun on the grounds that they lacked proper cause violated their Second Amendment rights. So walk us through this case and where you think the court will land on this one.
Sure. This is a case I'm fairly familiar with. I have a brief in that case actually for the California Gun Rights Foundation, talking about some of the past problems with Second Amendment litigation, standards of review, the inclination of lower courts to misapply those standards or ignore those standards, et cetera, not the least of which is the court in your circuit, the Ninth Circuit, tends to always vote against the Second Amendment. But the issue really at heart is twofold. One, does the amendment actually mean it when it says the right to bear arms? Does that mean you get to carry them? Or is it just about the right to keep arms? And many courts have been treating the bear part as undecided and limiting Heller to its facts. You get to keep it in your home. You can't possibly take it anywhere. So that's very important, just to establish that, yes, there's a second part to the Second Amendment. But it's also about the very nature of a constitutional right, which I think, while important in the Second Amendment context, is important more broadly. You know, a constitutional right is not something you have to justify. It is something that the government has to justify its abridgment of. And here New York gets it literally and exactly backwards. It says, you don't have a right to this. It's a privilege. And it's only a privilege that we will give you if you can show that you're somehow special in our eyes. But of course, a constitutional right is something that doesn't require showing that you're special. It applies to everyone. And so hopefully, and I think the court will, sort of make that clear that at the end of the day, constitutional rights are not discretionary. Constitutional rights are not something the rights holder has to defend, but rather the rights taker has to justify infringement of. And I think they will go there. The one thing I fear is a fractured opinion that tries to get a little wishy-washy on the standard and still maintain considerable room for states to justify restricting carrying arms with just the barest or weakest of arguments and evidence. You can sort of see the middle of the court being a little uncomfortable with just having an armed populace roaming the streets. And I fear that that concern, even though I don't think it's justified, I fear that that concern will drive a continuation of these loosey-goosey balancing tests that put inadequate burdens on the state to prove their need and justification for infringing upon rights. But at the end of the day, I think you will see a win for the Second Amendment. The only thing I fear is that that win will not be definitive enough or establish a sufficient bright line to deter the shenanigans of certain courts like the Second Circuit and the Ninth Circuit, which seemingly are willing to come up with any half-baked excuse to ignore the Second Amendment. So hopefully we'll see something that deters that, but I'm 50-50 on whether the details will be enough to stop the resistance some of these circuit courts have to Second Amendment protections.
Carson versus Mackin is a case about religious freedom and the separation of church and state. So several families are challenging a law in Maine that forbids families from applying for state tuition assistance if those funds are going to be used to pay for students' secondary school education at a school that taught religion. Now, in 2020, the Supreme Court ruled that states don't have to provide public funding for private schools, but if they do, they can't discriminate based on the religious status of the institution. So the issue here is whether public funding can be denied to schools that provide religious or sectarian instruction. Now, I'm not a lawyer, but it seems to me that this is already happening at the university level. So why not secondary education? How do you think the court's going to rule on this?
Well, again, this is another case I'm quite familiar with. I have a brief in that case as well for a group called Protect the First, arguing in favor of the parents. And I think this case is actually fairly easy and will come out in favor of the parents. This earlier case called Espinoza said you can't discriminate based on religious status. And now the question is whether or not the fact that you're not merely sort of religion light or religion in name only, but actually, God forbid, practice your religion, whether that's enough to let states discriminate against you. And I think the short answer is no, it's not. Remember, the central issue in cases like Espinoza and in any of the voucher cases, and here, is whether or not the parental or student choice in where to go to school sort of breaks the connection between state funding and religion, whether it sort of takes away any notion of establishment. And I think the answer over and over again is that yes, it does break that link. The state is not the one choosing the religions. The state is not the one choosing the schools. All the state is doing is subsidizing a private choice in a way that I don't think implicates establishment clause. Now, the brief we wrote for PT1, Protect First, sort of pointed out that, look, if you allow Maine's rule to stay in effect, what you're actually doing is discriminating among religions. Religions that are fairly laissez-faire in sort of how one goes about practicing one's religion are happy to set up schools and, say, hi, we're Georgetown University, we're Catholic, but, you don't actually have to have any Catholic teaching here. You just have to have the name on the cover. That's sort of the religion light version of schooling. Whereas any school that sort of incorporates their teachings into the curriculum, sorry, if that's your religious obligation to incorporate the teachings of your faith, too bad, so sad. And that's a serious discrimination between favored versus disfavored religions. Very similar, by the way, to the Coach Kennedy case, the Kennedy versus Bremerton case of, if you're really religious, if your religion actually asks you to do anything, we can discriminate against you. But if your religion lets you just slap on a label but ignore everything else, then you're good. You're a good religion. The other folks are bad religions. And that seems far more damaging and dangerous than any indirect implication that the state is supporting religion by letting parents have their own choice. And I think that's true at the secondary level. I think it's true at the college level. Could you imagine saying that you can't get a Pell Grant or a student or a subsidized student loan if you happen to go to a religious university? I think the sole issue ought to be, do the schools teach the things that we want schools to be taught? And the fact that they teach more as part of their religious obligation really has little or nothing to do with any notion of establishment. Equality means I get to learn math and science and English at a secular school, at a religious school, at a religion light school, whatever I want, as long as they're teaching me math, science, and English. And if they happen to throw in a little bit of religion on the side, or a lot of religion on the side, that's really a private choice, not a state choice.
CVS Pharmacy versus Doe raises the issue of whether policies that disparately impact disabled groups violate the anti-discrimination provisions of the Rehabilitation Act and the Affordable Care Act. So the John Does in this case are enrollees of employer-sponsored health care who have HIV. Now, CVS provides the John Does with their medication. So the respondents sued CVS after CVS implemented a new medication policy that required all specialty medicines to be mailed if they wanted the medications at the in-network price. But if they want their medications in person, they'll be charged a higher rate. Now, the respondents believe that they're being denied meaningful access to medical care. Now, that description alone shows how in the weeds this case can get, but it's a very important case. So what's at issue here?
Well, let me start by saying I don't have a brief in this case. And also, to get even further in the weeds, on the eve of oral argument, or shortly before the eve of oral argument, CVS voluntarily dismissed its appeal, seemingly because the PR and business consequences of pushing this were too severe for CVS, not the legal consequences. So while I think the legal questions are actually quite interesting and quite important, the case itself is a dead letter because CVS has a long-standing relationship with disability rights groups, and bucking them and bucking the federal government on this was bad for business and bad for PR. So, CVS made a choice that was, valuable for its own business interests, and I respect that. But the issue itself is still important and may or may not come up in the future. I imagine that other large healthcare companies and pharmacies will like CVS, be a little redundant to dump all over the disability community by fighting them on this. But I think it is a very important issue whether disparate impact is a valid basis for a discrimination claim, because there are disparate impacts for lots of things. The very fact that you're disabled means the entire world disparately impacts you in some way or another. And the question about whether the failure of private parties to compensate for the things that make life more difficult to you constitutes discrimination on their part is a quite bold and aggressive stance. I understand in some instances that could be the case, but here's a good example. There are certain drugs that are used for rare types of diseases or disabilities that, pharmacies may not stock on a regular basis. It's not like they're stocking acetaminophen. This is a drug that maybe can't be kept at every single CVS on the planet, that has to be shipped separately. And the notion that it costs more to provide rare drugs to smaller populations, you would think that means you get to charge more for it. Because if you don't, that really throws an interesting kink into sort of ordinary business decision making, that you have to subsidize everyone so that all drugs are equal cost. Otherwise, somehow the person with a rare disease is being discriminated against. So I think it's important to really probe further, whether it's in the context of disabilities, whether it's in the context of race or gender or anything else, whether the simple fact that these kinds of differences in circumstance can lead to differences in outcome is on its face discriminatory or raises a charge of that. I think that's very important. I think we'll see other cases raising it. It may not come up in the disability context, but the arguments at the end of the day in one context will impact on other contexts. So whether it's race, gender, sexual orientation, whatever it is, even voting, sort of the whole notion of disparate impact is a sweeping reconception of what it means to discriminate, where there was no intent to do so. There just happens to be differential outcomes.
So United States versus Zebeda is a fascinating case that involves state secrets privilege. The Supreme Court held that courts must exclude privileged evidence if it threatens our national security. So Abu Zubaydah was a former associate of Osama bin Laden who was detained in Pakistan by the CIA for being an enemy combatant and put in a detention facility in Poland. So during his time there, the CIA used enhanced interrogation techniques on Zubaydah. Poland launched a criminal investigation into the CIA's operations there, and Zubaydah asked a U.S. federal district court to order the U.S. government to provide Poland with information about his detention. The court is deciding whether some of the material can be released. It's an intriguing case. What do you think?
Well, I think the court, came down on the CIA's side in this case and held that the state secrets doctrine did apply. It reversed the Ninth Circuit in a 7-2 decision. It was an interesting lineup, by the way, right? Justice Breyer writes the decision, most of which is joined by six others, including many of the conservatives. The two dissenters were Justice Gorsuch and Justice Sotomayor. Sort of an interesting pair up. It's happened before. And it's sort of a very fascinating, more libertarian take from Justice Gorsuch than perhaps for some of the others, which is sort of refreshing, I have to say. But at the end of the day, I am not a fan of the way the state secrets doctrine interacts with the rest of our legal system. I absolutely agree that you can't reveal troop movements, you can't reveal the names of our spies in different countries, and perhaps you can't even reveal certain types of cooperation with foreign nations. Now, the question of whether those obviously important government interests outweigh the need to check the government from terrible and bad behavior, like torture or like violation of other constitutional rights, poses an important dilemma. And at the end of the day, I find it less about the particular details of this case, whether or not confirming information that had publicly leaked is sufficiently important to keep a secret versus whether the leak basically undermines the government's interest enough that you can go ahead and litigate it. It is not about whether or not you get discovery, even though that's what this narrow case was about. What it really is about at the end of the day is whether the underlying criminal case or an underlying civil case even will crater because the government refuses to give any evidence that would show their bad behavior. There's a related case up at the court that was decided also in favor of the government called FBI versus Fazaga, which had sort of proposed, the lower courts, the Ninth Circuit again, had proposed a solution to this dilemma by having the FISA court, the Foreign Intelligence Surveillance Act court, sort of review some of this secret evidence in camera in order to see whether there was a legitimate constitutional violation. And the Supreme Court said no, for reasons that largely dealt with statutory interpretation. But I think highlights the need to do something about what happens when state secrets privileges stop you from holding the government accountable for its unconstitutional or otherwise illegal behavior. There has to be some version of a remedy, because without a remedy, constitutional and other types of rights are effectively vitiated. Once again, I don't have a brief in Zaveda, but I did have a brief in Fazaga, the Foreign Intelligence Surveillance Act case against the FBI for a group called the Project for Privacy and Surveillance Accountability, PPSA. And I think it's an important question that keeps recurring, as we'll see in a few minutes when we get to some later cases, about how do you check the government from bad behavior if the courts are unwilling to step in, whether because of privilege assertions or sovereign immunity assertions or what have you.
So another big case is, interestingly, a regulation that never took effect. So our listeners might remember the Clean Power Plan. It was a federal regulation that governs emissions from power plant. Now, PRI has done extensive analysis on this plan and put out a big study on it back in the day. Now, when President Obama announced the Clean Power Plan, he planned to require each state lower carbon he planned to require each state reduce carbon dioxide emissions from the electricity sector, primarily by replacing coal-fired power plants with wind and solar. But after lawsuits from some of the states and the coal industry, the Supreme Court put the program on hold. Now, when President Trump took office, he brought out a new plan that was effectively the same as no regulation. But on the last full day of Trump's presidency, a federal appeals court found that the Trump administration had, quote, misconceived the law and vacated the Trump plan. So now the Biden administration wants to bring back a form of it. Now, as you can tell from this description, this is a pretty odd case because there isn't actually a real law here. So why do you think the court decided to take this up at all?
Well, I think it's more about the procedural bizarreness of it and dealing with things that plague courts in general rather than the particular substance of the case. So the substance of the case, interestingly enough, is about this incredibly narrow statutory interpretation question. They sort of call it, whether or not you can regulate point sources for carbon emissions inside the fence versus outside the fence, i.e., do you have to put something over their smokestack, or can you let them trade it off with things that happen somewhere other than the facility emitting pollution? And that's an interesting environmental question, but it's not that interesting, to be honest. What's more interesting is how one goes about deciding these questions and interpreting these questions, how one goes about letting the EPA interpret a potentially ambiguous statute, the usual Chevron deference kind of questions. All of those are the underlying questions. But right now, given the back and forth, the real issue is, are courts even properly getting involved at this moment, given that we're still waiting for the Biden administration to sort of make a choice about what its regulation is going to be? And I think it raises a couple of interesting questions procedurally. First of all, the Clean Power Plan is still the regulation. It's still the extant regulation. It's just been stayed. So it's not in effect, but it's still arguably a valid regulation. It's just been stayed by a court. It's not at all clear to me that a district court staying a regulation or even a law somehow moots the case. and makes it go away for purposes of subsequent appeals. So there, I think that's sort of important, an important question that it ties into the difficulty with the time that it takes to get through the federal courts. It takes years and sometimes decades to get through some of these big regulatory cases, so that by the time you get to a Supreme Court or even a meaningful circuit court, things have changed, the law has changed, and you never get sort of final decisions on very important questions. And this sort of goes to that, is when are you forced to stop paying attention to a case because events have overrun the underlying controversy? And I think, I don't know how they're going to come out. There are good arguments on both sides in this one that you don't decide issues that no longer have immediate impact, where the political branches may make it unnecessary for you to decide. We feel like the Supreme Court butts its nose into all parts of American life. And this could be an example of them sort of staying out of it, where the political branches are sort of sorting things out by themselves. And that's laudable. On the other hand, it is incredibly frustrating to spend 10 years litigating something only to sort of not be able to get a final answer and have that whole 10 years thrown in the toilet because you had a couple elections in between. And at least for the next 10 minutes, they're not going to do the thing that is hurting you, but in the next election, they will. So you can keep getting whipsawed back and forth as administrations change of, yes, you have to do it. No, you don't. Yes, you do. No, you don't. And you never actually get a legal ruling on whether such sort of executive branch flip-flopping is okay. And that's a problem. That's a serious problem in terms of predictability of rights, predictability of the law, et cetera. So I think they took it for those reasons. I literally have no idea how they're going to come out. But I think it is an interesting set of issues for them to grapple with, both here and I'm sure in many future cases.
So finally, Shirt Left versus City of Boston is a First Amendment case. A Christian group filed a lawsuit after the City of Boston denied their request to fly a flag with a cross over City Hall. The group argues that the city lets other groups to use the flagpoles and that the denial of their application violates their First Amendment. Both the district court and the First Circuit ruled for the city. What are your thoughts on this case?
Once again, a case I'm very familiar with, having a brief in that case for a group called Protect the First, which I mentioned earlier. And we were fully in support of the First Amendment side of this fight. So the prospective flag flyer. Boston had claimed that the flagpole was its own government speech rather than simply a forum for other people to sort of fly flags. And I have to say, I viscerally hate that position and the entire government speech doctrine, quite frankly. I think it is disingenuous. I think it grotesquely masks government censorship by pretending that it's government speech. And so I think Justice Alito, in his opinion, got it exactly right for reasons that I wholeheartedly agree with. And in fact, for many reasons that we sort of advocated in our amicus brief. It's one thing for the government to say, hi, I'm going abroad to chat with some foreign leaders, and the United States is going to take a position on Russia, on the Ukrainian war, on trade, on China, on Taiwan. Yes, the government speaks with the government's voice when it goes out and negotiates treaties, when it goes out and criticizes foreign nations, when it does all that diplomacy. But within the United States, when the government just decides, hi, I'm going to pick the people I agree with, adopt their speech, and then give them preferential access to the avenues of communication, that's appalling. Just imagine if the government said, we're going to pick up a billboard and pay for it, and we're just going to let one party put their signs on it because it's our speech and we like that party. So, hi, I'm a Democratic administration, so the billboard is going to say vote Democrat. Or, hi, I'm a Republican administration, and the billboard is going to say vote Republican. That, to me, is not government speech. That, to me, is government censorship. And more importantly, it's sort of government support in a viewpoint discriminatory way. So I think Justice Alito's focus in the decision of focusing on, is the government actually speaking, or is it exercising censorial power over the speech of others, is an important line to draw, and to draw strictly. That government control over someone else's message does not convert other people's speech into government speech. Government speaks when it is conveying its own message in a proper manner that it is entitled to do. But I indeed would have gone further than Justice Alito, but I am very happy that he went as far as he did.
So before we close here, could you talk to us about a few cases that aren't getting a lot of attention, but that you think are important or would have lasting implications?
Sure, absolutely. Though the not getting a lot of attention part, I don't know that I get it there, but there are several cases we haven't reached out that I'll just touch upon briefly that I think are important and have lasting implications. From this term, I think the Whole Women's Health versus Jackson decision, which is Texas's SB 8 private enforcement of a ban on abortion, is an incredibly important decision, not because of its abortion implications, but because of its implications regarding the enforcement of constitutional rights of any stripe. Once again, I had a brief in that case for a group called the Firearms Policy Coalition, a gun group, which has no position at all on abortion, but has a very strong view about how one goes about enforcing constitutional rights like the First or Second Amendment. And not surprisingly, California copycatted Texas and is now trying to apply similar techniques to guns, to restrictions on guns. And that case is important because it allows states to set up enforcement regimes that circumvent federal court review, that put these kinds of cases in local courts and then make it incredibly difficult, if not impossible, for local courts to enforce the Constitution in any meaningful way, and make it incredibly difficult for challengers to survive the litigation process, given the myriad other procedural due process violations and First Amendment violations baked into these laws. So I think that's an important case to watch about who do you get to sue when a state tries to infringe upon constitutional rights, whether you agree or disagree with the substance of those constitutional rights. Can you sue the state? Can you sue the courts? Can you sue the judges when the state sort of disables its own executive branch from enforcing these laws? And I would say that at the end of the day, we're going to see these kinds of issues coming back around in lots of contexts. And the question becomes whether old cases like Ex parte Young and Hans v. Louisiana, which say you can't sue the state directly, are really sensible, and whether they're consistent with the 14th Amendment. My personal view is that they're not, and that we need a little more precedent to go by the wayside in the hopefully near future. We'll see if that ever happens. Another case that I think is very interesting is a case called Egbert versus Boole, or Boole, I never know how to pronounce it, which is about whether a Bivens remedy exists. So an implied cause of action against federal government agents and employees for violating the Constitution, in this case, the Fourth and the First Amendments. The court over the years has been hostile to implied causes of action. On the other hand, when a federal officer or agent violates the Constitution, one wonders how one has a remedy for that, if not through an implied cause of action. And right now, it's looking like the court is pretty hostile toward giving them any remedy at all that Congress hasn't affirmatively adopted. Once again, like with the Whole Women's Health case, I think this implicates how one goes about enforcing the Constitution, and whether the Constitution is only enforceable against the legislative and executive branches if they feel like it. I again disagree with what is, I guess, the more natural conservative position here that says there's no such thing as an implied cause of action. Again, had a brief in that case for this privacy group that I do work with, PPSA, arguing that, in fact, courts have always had the power to enforce foundational and fundamental law, even against the sovereign. And that goes back to the common law, where the king and the king's agents were indeed subject to suit for damages if they violated the fundamental law. And I think that that power is incorporated into the Constitution via the words, the judicial power of the United States. So I think it's not implied out of nothing. It's in fact historically grounded in both the common law history of suits against the crown and the crown's agents, and suits and the phrasing in the Constitution of the judicial power. I'm not overly confident the court will agree, but that I think is the right answer. And again, means that, where you have these constitutional rights, you need some sort of remedy. Otherwise, those rights are fake. And for anyone who cares about constitutional rights, that should be important. There are a couple of other interesting First Amendment cases out there. Whether or not they will have long-term consequence or not really depends on how broad or narrow the decisions are. City of Austin versus Reagan National Advertising deals with what is content discrimination. It had a very narrow view of content discrimination. I don't agree with the case. It just sort of depends how that plays out in the future. I fear it plays out in a narrowing of First Amendment protections. Kennedy versus Bremerton, by contrast, deals with sort of private expression of religious belief in public settings. And once again, it sort of depends on how broadly or narrowly the court decides that. The Kennedy versus Bremerton is the praying football coach. And so there's an interesting line between private religious expression that happens to take place at the workplace. Imagine wearing a cross, imagine Ash Wednesday with ashes on your forehead. It's private expression, obviously, but it would occur at the workplace versus using the workplace to advance religion and somehow sort of making your employer complicitous in that. As you might imagine, using certain government resources to proselytize. Where Kennedy falls upon, which side of the line Kennedy falls upon will depend on the court's view of the facts and how they read that. A couple other things for next term that are worth keeping an eye on. One, of course, is the affirmative action cases versus Harvard and UNC. Those will have a big impact on how we interpret the Equal Protection Clause and whether we give it sort of some teeth, even where it applies in ways that some folks think is a good version of discrimination as opposed to a bad version of discrimination. One hopes that we would oppose discrimination, intentional discrimination in all contexts, and that seems to be the case there. Another big and important case is the National Pork Producers Council versus Roth, again for next term. That deals with California's effort to regulate pork production all around the country, something that you guys are probably familiar with, but it raises very important Commerce Clause and extraterritoriality questions. And again, it's a curious situation in that conservatives are skeptical of the existence of what is commonly called the dormant or negative Commerce Clause, that the Commerce Clause somehow of itself restricts the conduct of states, even if the federal government hasn't passed a specific law pursuant to the commerce power. Once again, I had a brief in that case encouraging the court to take the case. They did so. I'll have a brief in that when the merits get briefed at the end of next month. And my view is that the Commerce Clause, at least in this context and in many other contexts, is indeed an exclusive grant of power that by its very nature and by the phrasing of the 10th Amendment does in fact restrict state power to regulate commerce. The federal government has the exclusive power to regulate interstate commerce and international commerce for that matter. And that power, having been delegated to the federal government, is not, quote, reserved to the states under the 10th Amendment. We'll see if I can persuade any of the conservatives that that's a historically grounded and textually accurate view. There's a lot of skepticism there, and so we'll see what happens. But the consequences of this case are huge, not just for people who enjoy pork, but for anyone who doesn't want to see a war of red states versus blue states, each imposing their own sort of efforts to force other states to comply with their moral views and their policy views and what have you. Imagine minimum wage laws, imagine abortion laws, imagine any number of laws where one state will try to impose its views on other states on the threat of excluding their products from that state's market. That seems like a terrible idea. It seems exactly what the Commerce Clause was designed to stop. We'll see where the court goes on that. Finally, two more things if you have a couple seconds. One is a case that people probably haven't paid a lot of attention to called Mallory versus Norfolk Southern Railroad, which is about whether a state can condition the right to do business in that state on a corporation allowing that state to have general jurisdiction over it, i.e. jurisdiction to hear cases involving behavior that did not, in fact, occur in that state. And that is a huge problem that deals with due process issues, that deals with Commerce Clause issues, and basically means that certain states will say, if you want to do business in my state, you have to let people sue you in my state for anything you do anywhere in the country. And again, it's sort of the same problem as the pork producers case, which is different states will then compete to sort of force companies to follow their laws no matter where they are, even when they're not acting within that state, just because otherwise you have to forfeit the right to do any business in that state. Again, a terrible idea, seems to violate the Commerce Clause, seems to violate the Due Process Clause, seems to be an unconstitutional condition on what I think is the right to engage in business in different states. And hopefully the court will reach that conclusion, but it'll have to find a theory to do it. Lastly, there are two two sort of circuit level cases to keep an eye on. One is a very recent case from the Fifth Circuit called Jarcasi versus SEC, which basically exploded the SEC's administrative adjudication process. I thoroughly applaud the decision. The court held that the SEC's in-house adjudication of sort of penalties, so using ALJs to adjudicate penalties, violates the Seventh Amendment. I think they're absolutely right. It also held that Congress unconstitutionally delegated power to the SEC when it gave it such sweeping discretion to effectively make law through its own vague processes, including through adjudication, which is almost standardless, that would violate the non-delegation doctrine. And finally, it sort of talked about the validity of SEC ALJs in that they're not removable by the executive branch and hence arguably violate the take care clause of Article 2. I think all of those are interesting and important decisions. And I think that case is a almost certain grant of cert if it survives the petition, the inevitable petition for en banc review. We'll see what the en banc Fifth Circuit says about that. It was a 2-to-1 panel decision, so that's no guarantee. But knocking out the SEC's adjudicative process, and by implication, the adjudicative processes of many other agencies, is a big deal. I think it's right, but I think the Supreme Court's going to have to weigh in if the Fifth Circuit en banc doesn't come to a different conclusion. And finally, there's a case kicking around both at the Fifth Circuit and a little bit at the Supreme Court called Net Choice versus PACT, which is Texas's effort to regulate social media and force them to be viewpoint neutral. This raises seriously important First Amendment questions, important Commerce Clause questions. The district court found that it violated the First Amendment and that it likely violated the First Amendment and issued a preliminary injunction. The Fifth Circuit, in a one-sentence order, stayed that injunction, effectively allowing that law to go into effect. And now Net Choice and company have asked the Supreme Court to reverse the Fifth Circuit stay and allow the preliminary injunction to stay in effect while the merits of that law and First Amendment claims and other claims are litigated. Once again, I sort of feel like Net Choice has the better argument here. I think the Fifth Circuit's stay of the preliminary injunction was a bold and incorrect move, particularly in the absence of any opinion explaining it. What the Supreme Court will do, on the other hand, is hard to say. I think the right answer would be to reverse the Fifth Circuit on this, go back to the stay issued by the district court, the preliminary injunction rather, issued by the district court, and allow the litigation to proceed in the normal course before this law takes effect. Because otherwise, there indeed will be irreparable harm. Large social media companies will have to completely revamp the way they do business, not just in Texas, but worldwide. And I think the law is almost certainly a violation of the First Amendment.
Thanks so much, Erik. Fascinating discussion.
You're very welcome. Happy to join you guys anytime you like. I always like coming to chat with you.